Court is in session in cause number 328-368. Case is style of State of Texas versus Reginald Cole. We have Mr. Cole appearing via Zoom. Mr. Cole, you can take your mic off of mute. Okay, I guess Mr. Cole is having problems taking his mic off of mute. Mr. Cole is represented by Mr. James Paget. Mr. Paget, how are you doing?
Doing well, Your Honor. Good morning.
Good morning, Mr. Paget. Mr. Cole's case is on the court's motion to revoke probation docket. Mr. Gilliam and Mr. Boyd, what is the state's position?
Your Honor, I'm having trouble hearing Mr. Boyd, but
No, he's not talking. They having a conversation amongst
okay. While they're having that conversation, Your Honor, I might catch the court up on what's going on. I've been working with Mr. Shearer and Mr. Boyd for the last few months on this case. Mr. Shearer for about the past 4 months. Mr. Shearer wanted my client to get in to find an inpatient facility, drug and alcohol treatment facility, and my client has done so. On Wednesday, my client was admitted into Centacor, and that's why he's having a little trouble with his microphone. He is in the Centacor facility right now as we speak. I'm in the process of getting documentation to support that, but that's what Mr. Shearer asked me to do. I know Mr. Shearer's intention was to get him drug and alcohol treatment and not to revoke, but that could have changed, obviously, but that was as of our last court setting.
Yeah, Mr. Gilliam?
Yes, sir. Probation recommends that we continue pending the outcome of pending the
That he attend and complete Centacor. Is that the plan?
Yes, sir.
Is that the plan, Mr. Boyd?
Yes, Your Honor.
Okay, so do we know how long the Centacor program is, Mr. Cole?
21 days, 21 to 30 days, sir, and they're gonna keep me here 21 days. And I did come in on Monday, not Wednesday, Mr. Paget.
I apologize. I got my days mixed up.
Okay, well, that's fine. So, Mr. Paget, you want to just a regular reset?
Whatever pleases the court, Your Honor. We're just very thankful that Mr. Cole stayed on top of this until he's a honorably discharged veteran who served our country, and thank goodness that they were able to help get him into this program, which he voluntarily entered. He realized he needs help, and I think he's going to be successful in the program. So if you would just give us maybe 30 to 45 days, maybe 45, just to get him out and get him adjusted.
Give us a reset date. You said January 20th. Okay, Mr. Cole, your case is going to be reset to January 28th of 2022. Mr. Cole, I don't know if I've told you in the past, but first of all, I'd like to commend you for taking the initiative to get into treatment to deal with the problem that you have. Now, the road to recovery is a marathon, it's not a sprint. And if you know the difference between a sprint and a marathon is a long race, a sprint is a short race. So the road to recovery is a long process. However, it always starts with the first step, and you've already made that first step. Now, as you continue on your journey, you may get weak along the way. However, you have people there at Centacor, as well as people in the probation office that you could lean on for support. So we'd like to encourage you to continue on your journey, and we're praying that you have a full and complete recovery. Your case is being reset to January 28th of 2022. Your attorney will be given a copy of your reset. Stay in contact with your attorney and your bondsman. You're free to go. You have a blessed day. And Mr. Paget, your reset will be sent to you.
Yes, Your Honor. Thank you.
Okay.
Yeah,
I'd like to
have a
point out,
blessed day.
I'd like to point out, Your Honor, that Mr. Cole actually did all this on his own, every single bit of it. He was not asked to, required, persuaded. He grabbed the ball and ran with it. He did every bit of it on his own.
That's commendable, because the first step of
Definitely.
recovery is to admit that, you have a problem. You've done that. And so, as I said, we'll be praying that you have a full and complete recovery. And at this time, both of your cases are going to be reset till January 28, 2022. This will conclude your cases. You have a blessed day.
You too, Your Honor, and thank you, Mr. Paget.
I'll be in touch, Mr. Cole.
Okay, y'all have a great, outstanding, blessed day.
Thank you.
Bye-bye.
Bye. The next case is cause number 321098. The case is style of State of Texas versus Rakeem Camille McBean.
Mr.
And we
McBean
have,
is on Zoom, Your Honor.
yes, we have Mr. McBean appearing via Zoom. Mr. McBean, how are you doing?
I'm doing all right, Your Honor.
That's good. Now, Mr. McBean, you're here represented by your attorney, Mr. James Paget.
Yes, sir.
Well, just hold on, Mr. Paget.
No problem, Your Honor.
Okay, probation officer trying to get his file. Okay. Now, Mr. Gillum,
Yes, sir.
what is the recommendation in Mr. McBean's case?
Probation's recommendation is revoked.
A revocation?
Yes,
Okay.
sir.
Now, Mr. Paget,
So
oh,
I do
excuse me.
understand that it was reset last time to do a plea deal.
Oh,
I
okay.
don't know the status of that.
Now, Mr. Paget, Mr. Gillum saying that the case was reset the last time for you to review a plea deal. Is that correct?
Yes, Your Honor, that is correct. And I've been over all the discovery with Mr. McBean. If you could set this on your plea docket, I'm quite certain that it can be worked out by the time we get back into court.
Okay, give us a plea date. Okay, it's going to be reset to January 24th, 2022. Mr. Paget, you can get your reset will be sent to you. And
Yes, Your
Mr. McBean, stay in contact with your attorney and your bondsman. You're free to go, and you have a blessed day.
You too, yes, sir. You have a good day.
All right, thank you.
All
The
right.
next case is cause number 326336. Case is style of State of Texas versus Donald Ray Augustus. We have Mr. Augustus appearing via Zoom with his attorney, Mr. James Paget. Mr. Augustus, how are you doing?
I'm doing fine. Good morning to you, Mr. Judge.
Good morning. Thank you. Now, Mr. Paget, what is your announcement in Mr. Augustus' case?
Your Honor, we have had some delays here. I'm not sure if you remember, I'll catch the court up. Mr. Augustus, several months back, actually donated a kidney to his brother. So he's been in a recovery mode here. The one thing I will say is that he has been in constant communication with me. I'd like to see what the probation department shows that he completed. He's given me documentation on his victim impact panel, his DWI education course, among some other things that he's completed on probation. And he's also working full-time now, trying to get back into work after his recovery. I also would like to point out that I spoke to Mr. Boyd about the case on our last setting, and he notified me that Mr. Augustus, one of the basis for the probation violation was he picked up a new DWI in Orange County. I've been constantly checking on that situation, and it has not been filed yet. So that's another holdup on the case because one of the allegations is new law violation. And as of today, there is no filing and there is no court date on the DWI in Orange County.
Okay, Mr. Gillian, you have
Yes,
an
sir.
update?
All the allegations here are based on that DWI, and our record shows that yesterday it has not been filed.
Okay,
It's compliant in every other area.
so he's complying in other every other area of his probation?
Yes, sir.
So you're just waiting to see what's gonna happen with the case in Orange?
Yes, sir.
Yes, Your Honor, and I hate that. Mr. Augustus has hired me for that case. And again, I'm staying on top of it. I have good lines of communication with Orange County. It should be filed by now, quite frankly. I checked yesterday myself and there was no filing. And then I talked to Mr. Augustus this morning. He's been in communications with his bonding company and there's no filing on his end either.
Do we know whether or not the case was refused or rejected by the
It was
DA's
not.
office?
It was not refused, nor was it rejected by the Orange County District Attorney's Office. That's the word. That's what they tell me.
Okay, so if all probability, they probably haven't received it, or if they have received it, they haven't made a decision on whether or not they're gonna accept it, reject it, or refuse it.
I think you're spot on there, Your Honor.
Okay, so at this time, we're gonna give you a, now, Mr. Augustus.
Yes,
Okay,
sir.
well, what we're gonna do, we're gonna give you a standard reset to keep track, just continue to do whatever you need. Continue, you're still on probation, you need to continue to adhere to the terms and conditions of your probation. Do you understand that?
Yes, sir. I was informed by Ms. Jones that she was requesting to not revoke because I completed all the terms and conditions of my probation. I spoke to her about 2 weeks ago. I actually went into the office and made the last payment, and I called her right after I was on last week to ask, by me being on probation, I do a lot of in and out of town work. But she said she asked to, because I don't work in Louisiana, Texas. I go, to different other states also. And
Mr. Augustus, Your Honor, Mr. Augustus and I discussed this. Of course, the state's not asking for revocation based on technical violations. He's caught up in current. Mr. Augustus, they're well aware of that. The issue we have is if they file a new DWI in Orange County, they're going to try to revoke you. So that's what we're waiting on. So everything that you just said, we're aware of. Everybody's aware of.
Yeah.
So let's not take up any more of the court's time when we just covered that. Okay.
Okay.
Yeah.
We talked about.
So what we're gonna do, give us a reset date. Okay, now, Mr. Augustus, your case is gonna be reset to January 28th. Is that correct? Of 2022. Your attorney will be sent a copy of your reset. Stay in
Yes,
contact
sir.
with your attorney, and stay in contact with your attorney and your bondsman. This will conclude your case. And as I said earlier, just continue to adhere to the terms and conditions of your probation. And so you're free to go. You have a blessed day. And Mr. Paget, your reset will be sent to you.
Yes, Your Honor. I'll forward it to Mr. Augustus as soon as I receive it.
Okay. Mr. Bailiff, would you please go get Robert Donata?
He should be in the audience outside, Your Honor. I spoke to him this morning.
Yeah, okay. Okay. I think it's on the docket. It says defendant. Is that Anelis Davila?
Still in Orange County Jail.
Okay. Okay, we're in session in cause number 326710. The case is styled of State of Texas versus Robert Lee Donata III. Mr. Donata, is that your full name?
Yes, sir.
How you doing, Mr. Donata?
Pretty good, Judge. How you doing?
I'm doing fine, Mr. Donata. You're here represented by your attorney, Mr. James Paget. Mr. Paget, what is your announcement in Mr. Donata's case?
Your Honor, after reviewing discovery and negotiating with the prosecutor, I've relayed the offer to my client. It's a $1,250 fine plus court costs with 1-day jail credit. I would ask, Your Honor, if the court would be so lenient as to give my client about 45 days to gather the funds. He is willing to accept that offer that the state has made.
Okay, so you just need time to get the money to pay the fines and court costs?
Yes, Your Honor, he is working full-time. I'm just concerned about right around the holidays here. If you could just give him a little bit more time than your normal
Okay.
reset.
So how much time do you need?
45 to 60 days at the court's pleasure, Your Honor, and the case will be disposed of.
Okay, give us a reset date. Okay, case is gonna be reset to January 21st of 2022. Mr. Donata, you're gonna get your reset here in court. You're gonna stand over there in front of the court coordinator. Once you give you your reset, you'll be free to go and you have a blessed day.
Yes, sir.
And Mr. Paget, your reset will be sent to you. And I think, Mr. Paget, will this conclude your cases?
Yes, Your Honor. I appreciate your consideration this morning. I hope you guys have a good weekend. May I be excused?
Yes, you may be excused and you have a blessed day.
You too, Your Honor. Thank you so much.
Next case is stated. We have some, please, ready?
Yes, I'm still working on something.
Okay. Our next case is going to be cause number 329-482. Case is style of state of Texas versus Tanya Marie Horst. Yes. Okay, same here. We're in session in cause number 329-482. The case is style of state of Texas versus Tanya Marie Horst. Ms. Horst, is that your full name?
Yes, sir.
Okay, Ms. Horst, would you please raise your right hand? Ms. Horst, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Okay, Ms. Horst, how are you doing?
All right, how you doing, sir?
Okay, I'm doing fine. Ms. Horst, you're here represented by your attorney, Mr. David Groves. Mr. Groves, how you doing?
Very good today, Judge. Thank you.
And Mr. Groves, do you waive a record in Ms. Horst's case?
Yes, sir.
Ms. Horst, I have before me an information that alleges that on or about January 30th of 2021, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of possession of a controlled substance, penalty group 2A. Ms. Horst, do you understand what you've been charged with?
Yes, sir.
And to this charge, Ms. Horst, how do you plead guilty, not guilty, or no contest?
No contest.
Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Ms. Horst, I have before me a document that is titled the misdemeanor plea admonishment. Do you recognize this document?
Yes, sir.
On page 2 of this same document, Ms. Horst, there's a set of initials TH on a line next to a box that says check nola contendere, which means no contest.
Yes, sir.
Did you place your initials on this document?
Yes, sir.
On page 3 of the same document, there's a signature above the line that's titled defendant. Is that your signature?
Yes, sir.
And on the next document, which is titled the trial court certification of defendant's right of appeal, do you recognize this document?
Yes, sir.
Is this your signature above this, the line that's titled defendant?
Yes, sir.
There are two boxes at the top of this document. The first box states that this is a plea bargaining case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that?
Yes.
Ms. Horst, I have before me a document on paper that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
Is this your signature above the line that's titled defendant?
Yes, sir.
Now, Ms. Horst, prior to signing and initialing these documents, did your attorney, Mr. Grove, go over these documents?
Yes, sir, I did.
And did you read and understand everything in these documents?
Yes, sir, I did.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State, I have before me State's Exhibit Number 1, the misdemeanor plea admonishment. You like to offer State's Exhibit Number 1 and State's Exhibit Number 2, the probable cause affidavit?
Yes, Your Honor.
No objections either, Judge.
Okay, no objections. State's Exhibits Number 1 and 2 are admitted. Mr. Grove, you've advised and counseled Ms. Horace. Is there any evidence that she is currently mentally incompetent to stand trial?
None that I'm aware of, Your Honor.
Ms. Horace, your attorney, Mr. Grove, has advised and counseled you. Are you satisfied with his representation?
Yes, I'm very satisfied.
Has he provided full, effective, and competent legal representation?
Yes, sir, yes.
Okay, Ms. Horace, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
What is that agreement?
7 days county jail. Ms. Horace says credit for 7 days time served, the court cost to be taxed and retired.
Ms. Horace, the state is offering that you serve 7 days in the Jefferson County Jail. However, you will not have to serve any more time in Jefferson County Jail because you've already spent 7 days. Therefore, you'll be given credit for time served. The court cost in this case is $387, but you would not have to pay the court cost because the time that you spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. Ms. Horace, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Ms. Horace, I'll follow the plea bargain agreement that you have entered into with the state. Ms. Horace, please stand on the X next to your attorney. You're going to follow the directions of our clerk. Once you finish following her directions, you'll be free to go and you have a blessed day.
Thank you.
And Mr. Grove, I think this is your only case?
No, sir, I have
You have
a
another one?
motion to revoke probation.
Okay. Okay, we'll get
Also
to,
as a plea.
okay. Who's your client?
Uh,
Oh, is it the McDowell?
McDowell, yes, Kavanta McDowell.
Okay.
Forgot her last name.
Thank
Okay, the court is in session and cause number 315624. Case is filed, the state of Texas versus Kivana Danae McDowell. Ms. McDowell, is your name Kavanya Danae McDowell?
you.
Ms. McDowell, would you please raise your right hand? Ms. McDowell, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ms. McDowell, you may put your hand down. How are you doing, Ms. McDowell? That's good. Ms. McDowell, you're here represented by your attorney, Mr. David Grove. Mr. Grove, do you waive a record in Ms. McDowell's case?
Yes, Your Honor.
Ms. McDowell, I have before me a motion to revoke your unadjudicated probation. This motion alleged that on March 14 of 2018, in County Court at Law Number 2 of Jefferson County, Texas, that the court found that evidence was sufficient beyond a reasonable doubt to support a finding of guilt for the offense of unlawful restraint. However, the court deferred adjudicating your guilt and placed you on unadjudicated probation for a period of 12 months. On January 24th of 2019, the state filed a motion to revoke your probation. And in this motion, there are several allegations. The first allegation alleged that you, Kavanya Danae McDowell, failed to report to the Jefferson County Probation Office as ordered by the court on December 13, 2018, as directed in violation of condition 4 of your probation order. Is that true or not true? And allegation number 2 alleged that you, Keviana Danae McDowell, excuse me, failed to pay court assessed fees as ordered by the court, and as of January 17, 2019, you were $806 in arrears in violation of condition 8 of your probation order. Is that true?
Yes, that's true.
Allegation number 3, allege that you, Cavania Danae McDowell, failed to abstain from the use and possession of any drugs except those taken, possessed under doctor's orders as ordered by the court, in that on or about November 13, 2018, that you, Keviana Danae McDowell, provided a urine sample for a scientific analysis that showed the presence of a metabolic byproduct, tetrahydrocannabinol, which is commonly referred to as marijuana, in violation of condition 12 of your probation order. Is that true or not true?
It's true.
And allegation number 4, allege that you, Cavania Danae McDowell, failed to perform the community service hours as required, as ordered by the court, in violation of condition 14 of your probation order. Is that true or not true?
True.
Now, Ms. McDowell, are you pleading to allegations 1, 2, 3, and 4 freely and voluntarily?
Yes, sir.
And are you pleading true to these allegations because they are true?
Yes, sir.
Okay. Now, Ms. McDowell, I have before me, let me see this here. Mr. What's that? Intention structure or?
Yes, sir, that is talking about the right to have probation. Since this is a revocation of probation, we can remove that, Judge, if you want us to, but
Well, it talks about judicial clemency. It talks about,
yes, sir.
Let's see, freely about that, that she's aware of the consequences of a plea, that she was mentally competent, and the plea is freely and voluntarily made. If counsel was appointed, you give up, waive any time to be to law prepare for trial. I mean, they have a lot of waivers. It's not just about probation.
Yes, sir. That's what I did, and we can remove that. She's aware of all those rights.
Yeah, I know. Okay, so I'm gonna let you do it because if, by
Yes, sir.
striking through it, I mean, it almost says if you didn't go over it with her. I need to do that. Oh, you know what? Another thing I saw there, where it has 1-4, you have to put 1, 2, and 3 and 4 for the allegations that she's pleading to. They have to
Okay.
be, each number has to be individually on it. Okay, thank you.
Yes, sir.
Now, Ms. McDowell, I have before me a document that is titled misdemeanor plea admonishments. On page 1, it has an X on a box that says check MTRP. MTRP means motion to revoke probation. Do you understand that?
Yes, sir.
Now, do you recognize this document? On page 2 of the same document, there's a set of initials, KM, on a line next to a box that's checked MTRP, true to allegations 1, 2, 3, and 4. Did you place your initials on this document?
Yes.
And on the next page of the same document, there's a signature above the line that's titled defendant. Is that your signature?
Yes, sir.
And on the next document, this document is titled trial court certification to defendant's right of appeal. Ms. McDowell, do you recognize this document?
Yes, sir.
Is this your signature above the line that's titled defendant?
Yes.
There are 2 boxes that are checked at the top of this document. The first box checks state that this is a plea bargaining agreement and you have no right of appeal. Do you understand that?
Yes.
The second box states that you're waiving your right to appeal, which means you're giving up your right to an appeal. Do you understand that?
Yes.
Now, Ms. McDowell, prior to signing and initialing these documents that I've just mentioned, did your attorney, Mr. Grove, go over these documents with you?
Yes.
Did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
State, I have before me State's Exhibit Number 1. State, you like to offer State's 1?
Yes, Your Honor.
Any objections?
No objection.
No objection. State's Exhibit Number 1 will be admitted. Mr. Grove, you advised and counseled Ms. McDowell. Is there any evidence that she is currently mentally incompetent to stand trial?
None that I'm aware of.
Ms. McDowell, your attorney, Mr. Grove, has advised and counseled you. Are you satisfied with his representation?
Yes.
Has he provided full, effective, and competent legal representation?
Yes.
Ms. McDowell, I would accept your plea of true. I will find that you are mentally competent to stand trial. I will also find that your plea of true to allegations 1, 2, 3, and 4 were freely and voluntarily given. And I will also find that there is sufficient evidence to revoke your unadjudicated probation. And your unadjudicated probation is hereby revoked. State, do we have a plea bargain agreement?
Yes, Your Honor.
What is that agreement?
The agreement is for 30 days jail with 30 days credit for time served, tax and retirement.
Okay, Ms. McDowell, the state is offering that you serve 30 days in Jefferson County Jail. However, you will not have to serve any more time in Jefferson County Jail because you've already served 30 days in Jefferson County Jail. Therefore, you'll be given credit for time served. The court cost in this case, Ms. McDowell, is $127, but you will not have to pay that court cost because the time that you spent in jail has already paid it off. Therefore, the court cost will be taxed and retired. Ms. McDowell, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes.
And do you accept the state's offer?
Yes.
Okay, Ms. McDowell, I'll follow the plea bargain agreement that you have entered into with the state. Ms. McDowell, please stand on the X next to your attorney, follow the directions of our clerk. And once you finish following her directions, you'll be free to go and you have a blessed day. Thank you.
Thank you.
Thank you. And you have a blessed day as well, Mr. Grove.
Thank you, Judge. May I be excused?
Yes,
Thank you.
we got Ms. Stell Howard. Where's that?
So, you're good to go. So here's just a copy of your paperwork for your.
All right, I'm doing fine. We're in session in clause number 329896. Case is style, the state of Texas. The case is style, the state of Texas versus Ms. Stell Renee Howard. Ms. Howard, is that your full name?
Yes, sir.
Okay, Ms. Howard, would you please raise your right hand? Ms. Howard, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Ms. Howard, you may put your hand down. Ms. Howard, you're here represented by your attorney, Attorney Giles Cole. Attorney Cole, how you doing?
I'm doing great, Your Honor.
I'm doing fine. Attorney Cole, do you waive a record in Ms. Howard's case?
Yes, sir.
Ms. Howard, I have before me information that alleges that on or about March 1st of 2021, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of criminal trespass. Ms. Howard, do you understand what you've been charged with?
Yes, sir.
And to this charge, Ms. Howard, how do you plead? Guilty, not guilty, or no contest?
Yes, sir.
Now, are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes, sir.
Ms. Howard, I also have before me a document that is titled the misdemeanor plea admonishment. It's also labeled as State's Exhibit Number 1. Do you recognize this document? On page 2 of this same document, Ms. Howard, there's a set of initials on the line next to about this check guilty. Did you place your initials on this document?
I did.
on page 3 of the same document, there is a signature above the line that is titled defendant. Is that your signature? And on the next document, which is titled trial court certification of defendant's right of appeal, do you recognize this document? And is this your signature above the line that's titled defendant? There are 2 boxes that are checked at the top of this document. The first box states that this is a plea bargain case and you have no right of appeal. Do you understand that? The second box states that you're waiving your right to appeal, which means you're giving up your right to an appeal. Do you understand that? Discovery certification. Ms. Howard, I have another document before me. This document is titled Discovery Certification. Do you recognize this document? Is this your signature above the line that's titled Defendant? Ms. Howard, prior to signing and initialing these documents that I have just mentioned, did your attorney, Mr. Cole, go over these documents with you? And did you read and understand everything in these documents? And is everything in these documents true and correct to the best of your knowledge? State, I have before me State's Exhibit number 1. State, you like to offer State's 1?
Yes, Your Honor.
No objection.
Okay, no objection. State's Exhibit number 1 will be admitted. Mr. Cole, you've advised and counsel Ms. Howard. Is there any evidence that she's currently mentally incompetent to stand trial? Ms. Howard, your attorney, Mr. Cole, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided fully effective and competent legal representation?
Yes, sir.
Ms. Howard, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
What is that agreement?
The agreement is for 6 months deferred probation, a $300 fine, and 30 hours community service.
Ms. Howard, the state is offering that you serve 6 months deferred adjudicated probation. During the 6-month probationary period, you'll be required to pay a fine of $300 plus court costs of $402, which comes with a total of fine and court costs of $702. You also be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month, and you'll be required to reimburse the court-appointed attorney's fees of $250. And your total monthly installments for this case is $265. Will you be able to pay the $265 each month?
Yes, sir.
You'll also be required to perform 30 hours of community service and adhere to the other standard terms and conditions of this probation. Ms. Howard, do you understand the state's offer?
I do.
Do you think that the state's offer in your case is fair and just?
It is.
And do you accept the state's offer?
I do.
Ms. Howard, I'll follow the plea bargain agreement that you've entered into with the state. Ms. Howard, if you successfully complete this probationary period, this case will be dismissed. It will not appear on your record as a conviction, and you may qualify for a non-disclosure. You can talk to your attorney, Mr. Cole, about a non-disclosure. He's quite competent in those matters. Now, Ms. Cole, please stand on the X next to your attorney. You can follow the directions of our court coordinator, our court clerk. Once you finish following her directions, you'll be free to go, and you have a blessed day.
Thank you, Your Honor.
Oh, you're welcome. And this is your only case?
Yes, sir.
Yeah, you'll be free to go as well. And you have a blessed day. You have to sign the tab.
Can I get your right thumbprint on that blue light, please? You can remove your thumb. I'm gonna need your signature on that signature pad located in front of you. You won't be able to see it, but Holmes. Mr. Cole, can I get your signature?
She can.
Now, Ms. Howard, can I have you come?
Next
forward
case
and
is-
raise your right hand? Please swear that you've never before been given probation in this state or any other state. Regular or. Yeah, okay, was that here in Jefferson County? Okay, just in Jefferson. Okay. It was, okay. That's fine, and you have no other pending charges that you're aware of? All right, so here's your paperwork. We're gonna take this to the probation office that. has
Leo
been
Tompkins?
back to, Okay, so you're just gonna report here. Whatever you're doing. You're good.
Okay, y'all have a blessed day.
Thank you, Judge.
All right.
You're welcome. Okay.
We're in session in cause number 330432. The case is styled the state of Texas versus Leo Fronterio Tompkins. Mr. Tompkins, is that your full name?
Yes, sir.
How you doing, Mr. Tompkins?
I'm doing all right, so.
I'm doing fine. Mr. Tompkins, I have, Mr. Tompkins, would you please raise your right hand? Mr. Tompkins, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Okay, Mr. Tompkins, you may put your hand up. Mr. Tompkins, you're here represented by your attorney, Mr. Joel Vasquez. Mr. Vasquez, how are you doing?
Good, Your Honor. How about yourself?
I'm doing fine. Mr. Vasquez, do you waive a record in Mr. Tompkins' case?
Yeah, sure.
Mr. Tompkins, I have before me an information that alleges that on or about June 23rd of 2021, while you were in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 0.15 or more. Mr. Tompkins, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Tompkins, how do you plead? Guilty, not guilty, or no contest?
No problem.
Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Mr. Tompkins, I also have before me a document that is titled the misdemeanor plea admonishment. Do you recognize this document?
Yes, sir.
And on page 2 of this same document, Mr. Tompkins, there are a set of initials, LT on the line next to a box that's checked nola contendere, which means no contest.
Yes, sir.
Did you place your initials on this document?
Yes,
On page 3 of the same document, there's a signature above the line that's titled defendant. Is that your signature?
sir.
And on the next document, which is titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature above the line that's titled defendant?
Yes, sir.
There are 2 boxes that are checked at the top of this document. The first box check states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
Second box states that you're waiving, which means you're giving up your right to the appeal. Do you understand that?
Yes, sir.
Mr. Tompkins, I also have before me a document that is titled the Discover Certification. Do you recognize this document? You get it, you could get,
Oh, yeah, I see. Yes, sir.
and is this your signature on the line that's titled defendant? Now, Mr. Tompkins, prior to signing and initialing these documents that I just mentioned to you, did your attorney, Mr. Vasquez, go over these documents with you?
Yes, yeah.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State, I have before me State's Exhibit number 1, the misdemeanor plea admonishment. State, would you like to also offer State's Exhibit number 2, the probable cause affidavit?
Yes, Your Honor.
Any objections?
No objections to 1 and 2.
Okay, no objections. State's Exhibits 1 and 2 are admitted. Mr. Vasquez, you've advised and counseled Mr. Tompkins. Is there any evidence that he's currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Tompkins, your attorney, Mr. Vasquez, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Tompkins, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is that agreement?
365 days jail, probated over 18 months. $1,500 fine. 60 hours community service. EWI education course. Drug and alcohol assessment. And ignition airline.
Okay. Mr. Tompkins, I have before me a document that is titled, well, I have a judgment, but Mr. Tompkins, the state is offering that you serve 365 days in the Jefferson County Jail. However, you will not have to serve any time in the Jefferson County Jail in this case because you'll be placed on probation for 18 months. During the 18-month probationary period, you'll be required to pay a fine of $1,500 plus court costs of $422, which comes to a total of fine and court costs of $1,922. You'll also be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month. You'll be required to reimburse Jefferson County court-appointed attorney's fees of $250. You will pay Jefferson County DWI education class and initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, your total monthly installments, that is the total amount that you would have to pay each month while you're on probation, is $250. Will you be able to pay the 250? Excuse me. Now, the monthly installments is $205. Will you be able to pay the $205? You will also be required to perform 60 hours of community service. You'll be required to attend a DWI education class, and you'll be required to have a drug and alcohol assessment. You will also be required to install a DWI interlock device on any vehicle that you own or operate, and you will be required to adhere to the other standard terms and conditions of this probation. Mr. Tompkins, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Tompkins, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Tompkins, please stand on the X next to your attorney. You're gonna follow the directions of our court clerk. Once you finish following her directions, you'll be free to go and you have a blessed day.
Mr. Tompkins, can I go ahead and get your right hand set on that blue light, please? Now, Mr. Tompkins, can I get your signature on that signature card we're sitting in front of you? You won't be able to see it, but I will. All right, Mr. Vasquez, can I get yours? Mr. Tompkins, can you come forward and raise your right hand? You swear that you've never before been given probation or deferred adjudication for a felony or misdemeanor in this or any other state? Colorado? Okay, let me get my paperwork. Do you remember what county your name was? What county? I don't hear you very well.
Arapahoe.
That's in Colorado. And what were you placed on probation for? And do you remember what year that was?
I don't remember the year. It's around the time I got kept in my kids, so it's probably like 2000.
About what year was that?
About 2003, 2004 maybe.
2004? Okay, and you have no other pending charges that you're aware of? Okay. All right.
Mr. Bailey, would you go get Brandon Richards?
He's here, Your Honor. Okay, so let me check one more thing before you go. You can place your hand down.
You can come on up.
Okay. So you're just gonna report to this address, so things be legal, okay?
Sure you will.
This is cause number 330-482, case of style of state of Texas versus Brandon Andre Richards.
Yes, sir.
Mr. Richards, is that your full name?
Yes, sir.
Mr. Richards, how are you doing?
Good.
Okay, Mr. Richards, you're here represented by your attorney, Ms. Lori Perrazzo. Ms. Perrazzo, how are you doing?
I'm doing well, Your Honor. Thank you.
State is represented by attorney Julie Maxey. Ms. Maxey, how are you doing?
I'm doing well, Judge.
Ms. Perrazzo, what is your announcement in Mr. Rich's case?
I have a couple, Your Honor. First, with regards to the discovery, I do need additional time to finish reviewing the discovery. We've reviewed the paper discovery, but there is a DVD that we need time to review. So if I could have another reset to
Okay.
an announcement.
Okay.
And my second matter is I have filed a motion to modify bond conditions. I didn't get it filed until late. I had a hearing last night.
You say you got it filed late last night?
Well, it's been accepted. The state has been provided with a copy.
Okay, I mean, I hadn't put it with a copy. I mean,
And I emailed it to your office this morning too, just in case. But would you like to take a look at it?
you print the, could you print it off?
I'm checking to see if it's in the motion. Shouldn't take too long to review.
Okay. 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 I read the state. What's your position?
Your Honor, the state does not oppose the motion. I was able to speak with the complaining witness this morning. And the complaining witness stated that to me that she's in agreement with modifying the bond conditions.
Yeah, okay, well, of
And
course.
she is also here, Your Honor, as a witness.
Okay, I mean, she can. Okay, now you say the victim is here, or,
Yes, Your Honor, she is right here.
I mean, did you state you had any questions for the victim or Ms. Marazzo? Did you have any questions for the complaining witness?
Your Honor, I would like to call her as a witness.
Okay.
I have spoken to her personally before today's hearing.
Okay, you may call her up as a witness.
Okay, I would call Lakendra Norbert. Am I pronouncing it? Okay.
Okay, Ms. Norbert, would you please raise your right hand? Ms. Norbert, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, Ms. Norbert, you may put your hand down. Ms. Marazzo?
Okay, thank you, Your Honor. Ms. Norbert, I understand that you and Brandon Richards shared a child together. And since the court ordered that Mr. Richards have a GPS tracking device on him on September the 28th of this year, you've had multiple interactions with Mr. Richards regarding, or just correct? Yeah. I apologize. I want to give you a complicated question. It's also my understanding that during these interactions, these interactions involve the possession exchange between you and Mr. Richards, correct? And several exchanges have occurred during that, since the time that the tracking device was placed on Mr. Richards until today. Yes. Okay. Have there been any incidents between you and Mr. Richards? I understand that this case revolves around an incident, without going into the facts, an incident which occurred at your location during one of the possession exchanges. Is that correct? Yes. Okay. Do you believe that if the GPS tracking device were removed today by the court, do you fear or do you believe that you were in danger in any way? No. Are you in fear for your safety in any way? No. Do you believe that GPS tracking device creates a burden for Mr. Richards? Yes. Financially, a financial burden? Yes. Yes. And also just a physical burden, because he's required to wear it at home and at work and at all times, correct? Yes. To the best of your knowledge, has there been any incidents of violence towards you and towards others that you're aware of during the pendency of this case? Okay. And do you have any knowledge of Mr. Richards not appearing before the court for any court hearing? Okay. I would pass the witness at this time.
Are you and Mr. Richards still in a relationship? No, yeah. And so do you have any other interactions besides what we spoke of earlier about exchanging the children? No. And do you have any knowledge of any threats that have been made to you or anyone else during the pendency of this case? State pass witness.
I have no more questions of this witness.
Okay. Is there a court order for custody that's in place?
Yes, Your Honor, there is.
Okay. Now, I know she testified that they've had, I guess, multiple exchanges. Does that court order provide for a third party to be involved in exchange as well? No. I think most standard orders, if it's a standard order, they may have that provision in there.
I didn't, if it is, I didn't see it.
No, sir.
Okay, well, the reason why I'm saying, from what she's saying, is that apparently he's been violating this bond condition. If they've had condition number 3 says that the defendant shall not communicate either directly, indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim.
Your Honor, if I may explain that, it's my understanding that when there is an exchange, he doesn't actually see the victim. He simply stops near the residence, the child gets out, he watches the child go to the residence.
He's not even supposed to
and
go
he
to the
doesn't have-
residence.
Not the resident.
I'm
We go
I'm
to,
sorry.
to the movies. I'll be inside the mall. she'll
Yeah,
pull up and drop me
but-
something.
I mean, what he's saying is he's violating the court order. He's violating the bond conditions.
I mean, officers are there.
I mean, yeah. You have that's why I asked you about the court order. The court order gives you another option where you don't have to show up.
My
A
sister
third party could exchange your children.
Mhm.
Your sister could drive over to where she is. I'm just saying, but so, the other thing is, when these bond conditions were set, the court considered the facts, the alleged facts of the case,
Yes, sir.
okay? Which, obviously nobody brought up, but, the court has taken judicial notice of the probable cause affidavit that's in the file. And, one of the rules for setting bond, the court has to consider, the future safety of the victim of the alleged offense and the community. All of those things shall be considered. Looking at those facts, the alleged facts, that was the main reason, one of the reasons why the court required that he have a GPS monitor on, GPS monitor on. I mean, he's coming to court. It's kind of like, I don't want to use a civil term which says a person that he didn't have clean hands because he's saying that he's violating the court order. And now you want the court to do away with bond conditions. Bond conditions are there to protect the victim as well as the community. That's the main reason why that condition was on there. And obviously, he's not even complying with those conditions. I understand that he said, well, he's not aware that a third party could exchange the children because apparently they hadn't, I guess, read that court order thoroughly. But at this time, the court is not going to be inclined to remove this condition. Obviously, if he is, if there have not been any violence or threats, that's the purpose for the court order.
Yes, sir.
To make sure that they will not have any threats or violence. And so the court is not going to remove, at this time, the court is going to continue to keep this as a condition of his bond. Okay.
Your Honor, I would ask at this time, if it's possible, if you would consider removing the condition that the defendant have no contact with the complaining witness in this case, Ms. Norbert, due to the issues that they may or may not have with the possession exchange of the child. Because not every time is there somebody that's available to assist in the exchange. And so if I would ask the court to consider at least modifying that portion of the bond.
No, I mean, right now we have peace between the parties. And I think one of the reasons why we still have peace is because of these bond conditions, and the court is not going to be inclined to remove those bond conditions. The court is not going to, the court is going to deny the modification of the bond condition of these bond conditions. Court is going to continue to keep these bond conditions in place because the court is wants to make sure that the community and the victim is safe.
Yes, sir.
Okay.
Thank you.
All right.
So I would have to get somebody to call her to get my son.
Your attorney could advise you on that. Y'all have a court order. You can read the court order that you have in place. It explains everything in there.
Oh.
Thank you, Judge.
Okay. Yeah, Miss. Get your reset.
Okay. Yes, ma'am. Not yet.
Yes. Yeah, we ready. Y'all have Mr. Moore.
That's it. Yeah, I have an announcement online, but we can do that afterwards. Or before, first, what do you prefer? I have Christopher Avila's on Zoom.
Let's see, 17. Okay, let's, okay. Let's see how to do this. We're in session in 3 cases. First case is cause number 317-528. Second case is cause number 317-596. And the third case is cause number 317-626. All 3 cases are styled the state of Texas versus Tyler Garrett Moore. Mr. Moore, is that your full name?
Yes, sir.
Mr. Moore, would you please raise your right hand? Mr. Moore, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. Mr. Moore, you may put your hand down. How you doing, Mr. Moore?
Do well.
That's good. Mr. Moore, I have before me in cause number 317-528, a motion to revoke your probation. In this motion, okay, in this motion, it alleges that on July 1st of 2018, that the court found evidence to be sufficient to find you guilty for the offense of driving while intoxicated. And your punishment was assessed at 180 days confinement, Jefferson County Jail, and a fine of $2,000. However, the confinement portion of your probation was probated for a period of 2 years. On March 9th of 2020, state filed a motion to revoke your probation. Now, in this motion, there are 7 allegations. State, are you abandoning allegations 2, 3, 4, 5, 6, and 7?
Yes, Your Honor.
Now, Mr. Moore, the state is abandoning allegations 2, 3, 4, 5, 6, and 7. And that just simply means that they will only be proceeding on 1 allegation. Now, the allegation that they are proceeding on alleges, or allegation number 1, alleges that you, Tyler Garrett Moore, committed the offense of driving while intoxicated, 3rd, on or about the 21st day of February 2020, in the county of Hardin, state of Texas, against the peace and dignity of the state in violation of condition 1 of your probation order. Is that true or not true?
It's true.
Now, are you pleading true to allegation number 1 freely and voluntarily?
Yes, sir.
And are you pleading true because it is true?
Yes, sir.
180, okay. Mr. Moore, I have before me a document that is titled the Misdemeanor Plea Admonishment. Do you recognize this document?
Yes, sir.
You have an X on the box that's checked MTRP, which means motion to revoke probation. On page 2 of this allegation, there are a set of initials on a line next to a box that's checked MTRP, true to allegation number 1. Did you place your initials on this document?
Yes, sir.
And on page 3 of this document, there's a signature above the line that's titled defendant. Is that your signature?
Yes, sir.
And on the next document, which is titled trial court certification of defendant's right of appeal, you recognize this document?
Yes, sir.
Is this your signature above the line that's titled defendant?
Yes, sir.
There are 2 boxes that's checked at the top of this document. The first box states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box states that you're waiving your right to an appeal. Do you understand that?
Yes, sir.
Now, Mr. Moore, prior to signing and initialing these documents, did your attorney, Mr. Galmore, go over these documents with you?
You did.
And did you read and understand everything in these documents?
I did.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State, I have before me State's Exhibit number 1. State, you like to offer State's 1?
Yes, Your Honor.
Any objections,
No
Mr. Galmore? No objections. State's Exhibit number 1 will be admitted. Mr. Galmore, you advising counsel, Mr. Moore, is there any evidence that he's currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Listen. Is this a deed of guy?
It is, Your Honor.
First, yeah, I think you're gonna have to put, I was just looking at, I just went to the order, it says 3 days. I think you're gonna have to say 72 hours, because that's how it is in statute.
Oh, okay.
Yeah,
No objection.
yeah, okay, it's the same, but it has to be, okay, now, let me get back to what I just caught my eye. Now, Mr. Moore, your attorney, Mr. Galmore, has advised and counsel you. You satisfied with his representation?
Yes, Your Honor.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Moore, I'm gonna let you change that. Mr. Moore, I will accept your plea true to allegation number 1. And I will also find that you are mentally competent to stand trial. I will also find that there is sufficient evidence to find you guilty, or there's sufficient evidence to revoke your probation, and your probation is hereby revoked. Okay,
Is that fine how I wrote it?
yeah, that's right. Now, State, is it, I wonder if she's gonna have to do the plea papers, like, is it, State, I think she's got to do it on each of the papers, but we could still do the plea.
Okay.
Okay. Now, State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is that plea bargain agreement?
The agreement is for 72 hours county jail with 72 hours time served, tax and retire the court costs. And that's to run concurrent with cause number 317596 and cause number 317626.
626, okay. Okay, now, Mr. Let's see what. Mr. Moore, the state is offering that you serve actually 72 hours in the Jefferson County Jail. However, you not have to serve any more time in the Jefferson County Jail because you've already served 72 hours. Therefore, you'll be given credit for time served. The court cost in this case is $67, but you will not have to pay the court cost because the time that you spent in jail has already paid off. Therefore, the court cost will be taxed and retired. Mr. Moore, do you understand what you've you understand the state's offer?
Yes, Your Honor.
Do you think that the state's offer in your case is fair and just?
Yes, Your Honor.
And do you accept the state's offer?
Good.
You accept the state's
Yes,
offer? Okay, Mr. Moore, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Moore, I have before me the next case, which is cause number 317596. And the motion, I have before me a motion to revoke your probation or your unadjudicated probation in this case. And in this motion, it alleges that on July 11th of 2018, in County Court Law Number 2, Jefferson County, Texas, that the court found that the evidence was sufficient to support a finding of guilt beyond a reasonable doubt, that you were guilty of the offense of resisting arrest, search, transportation. However, the court deferred adjudicating your guilt, and the court placed you on unadjudicated probation for a period of 2 years. On March 9th of 2020, the state filed a motion to revoke your unadjudicated probation. And in this motion, Mr. Moore, there are 5 allegations. Now, state, are you abandoning allegations 2, 3, 4, and 5?
Yes, Your Honor.
Mr. Moore, the state is abandoning allegations 2, 3, 4, and 5. Therefore, they're proceeding on allegation 1. Allegation 1 alleges that you, Tyler Garrett Moore, committed the offense of driving while intoxicated. Third, on or about the 21st day of February 2020, County of Hardin, State of Texas, against the peace and dignity of the state, in violation of condition 1 of your probation order. Is that true or not true?
True.
Now, are you pleading true to this allegation freely and voluntarily?
Yes, Your Honor.
And are you pleading true because it is true?
Yes, Your Honor.
Now, Mr. Moore, I also have before me a document that is titled Misdemeanor Plea Admonishments, which is also the state exhibit number 1. Do you recognize this document?
Yes, Your Honor.
And on page 2 of this same document, Mr. Moore, is this are these your initials on a line next to a box that's checked MTRP, which means motion to revoke probation, true to allegation 1.
Yes, sir.
And on page 3 of this same document, there's a signature above the line that's titled defendant. Is that your signature?
Yes, sir.
And on the next document, which is titled trial court certification to defendant's right of appeal, do you recognize this document?
Yes, Your Honor.
Is that your signature above the line that's titled defendant?
Yes, sir.
There are 2 boxes that's checked at the top of this document. The first box states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, Your Honor.
The second box states that you're waiving, which means you're giving up your right to an appeal. Do you understand that?
Yes, Your Honor.
Now, prior to signing and initialing these documents, did your attorney, Mr. Galmore, go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, I did.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State, I have before me state's exhibit number 1. State, you like to offer state's 1?
Yes, Your Honor.
Any objections?
No, sir.
No objections. State's exhibit number 1 will be admitted. Mr. Galmore, you're advising counsel. Mr. Moore, is there any evidence that he's mentally incompetent to stand trial in this case?
No, Your Honor.
Mr. Moore, the attorney, Mr. Galmore, has advised and counseled you. Are you satisfied with his representation?
Yes, Your Honor.
Has he provided full, effective, and competent legal representation?
Yes, yes.
Mr. Moore, I will accept your plea true to allegation number 1. I will also find that you are mentally competent to stand trial. I will also find that your pleas and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to revoke your unadjudicated probation, and your unadjudicated probation is hereby revoked. State, do we have a plea bargain agreement?
Yes, Your Honor.
What is that agreement?
The agreement is for 3 days credit for time served, tax and retire the court costs. And that is to run concurrent with clause number 317528 and 317626.
Mr. Moore, state is offering that you serve 3 days in Jefferson County Jail. You'll be given credit for any time that you are entitled to get by law. And Mr. Moore, the court cost in this case is $67, but you would not have to pay the $67 because the time that you spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. Now, Mr. Moore, we'll move on to your, well, Mr. Moore, do you understand the state's offer?
Yes, Your Honor.
You think that the state's offer in your case is fair and just?
Yes, Your Honor.
And do you accept the state's offer?
Yes, Your Honor.
Mr. Moore, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Moore, we'll move on to your next case. Your next case is cause number 317-626. And Mr. Moore, in that case, I have a motion to revoke your unadjudicated probation. And this motion alleges that on or about July 11th, 2018, in County Court of Law Number 2, Jefferson County, Texas, that the court found the evidence was sufficient to be beyond a reason without the supported finding of guilt. However, the court deferred the adjudication of guilt and placed you on probation for a period of 2 years. The state on March 9th, 2020, filed a motion to revoke your unadjudicated probation. And let's see. 96. And in this motion, in this motion, Mr. Moore, there are 5 allegations. State, are you abandoning allegations 2, 3, 4, and 5?
Yes, Your Honor.
Mr. Moore, state is abandoning allegations 2, 3, 4, and 5. Therefore, the state will only be pursuing allegation number 1. And in allegation number 1, Mr. Moore, the state alleges that you, Tyler Garrett Moore, committed the offense of driving while intoxicated on or about the 21st day of February 2020 in the County of Hardin, State of Texas, against the peace and dignity of the state in violation of condition number 1 of your probation order. Mr. Moore, to that allegation, how do you plead, true or not true?
It's true.
Are you pleading true? The allegation number 1, freely and voluntarily?
Yes, Your Honor.
And are you pleading true because it is true?
Yes, Your Honor.
Now, Mr. Moore, I have before me a document that is titled Misdemeanor Plea Admonishment. Mr. Moore, do you recognize this document?
Yes, Your Honor.
The box checked MTRP means motion to revoke probation. And on page 2 of this document, are these your initials on the line next to the box that's checked MTRP, true to allegation 1?
Yes, yes.
And on the next page of the same document, there's a signature above the line that's titled defendant. Is that your signature?
Yes, sir.
And on the next document, which is trial court certification, defendant's right of appeal, do you recognize this document?
Yes, Your
Is
Honor.
this your signature above the line that's titled defendant?
Yes, yes.
There are 2 boxes that's checked at the top of this document. The first box states that this is a plea bargain case. You have no right of appeal. Do you understand that?
Yes, Your Honor.
Second box states that you're waiving your right to appeal, which means you're giving up your right to appeal. Do you understand that?
Yes, Your Honor.
Now, Mr. Moore, prior to signing and initialing these documents, did your attorney, Mr. Galmore, go over these documents with you?
Yes, he did.
And did you read and understand everything in these documents?
Yes, I did.
And is everything in these documents true and correct to the best of your knowledge?
Yes, Your Honor.
State, I have before me state's exhibit number 1. State, you like to offer state's 1?
Yes, Your Honor.
Any objections?
No objection.
No objection. State's exhibit number 1 will be admitted. Mr. Galmore, you advise the counsel, Mr. Moore, in this case as well. Is there any evidence that he's currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Moore, your attorney, Mr. Galmore, has advised you. Are you satisfied with his representation?
Yes, Your Honor.
Has he provided fully effective and competent legal representation?
Yes, yes.
Mr. Moore, I will accept your plea of true to allegation number 1. I will find that you are mentally competent to stand trial. I will also find that your plea of true and waivers were freely and voluntarily given state. Do we have a plea bargaining agreement?
Yes, Your Honor.
What is that agreement?
The agreement is for 3 days, credit for time served, tax and retired of court costs. And that's to run concurrent with cause number 317-528 and 317-596.
Okay. Mr. Moore, the state is offering that you serve 3 days in Jefferson County Jail. However, you not have to serve any time in the Jefferson County Jail because you've already served 3 days in Jefferson County Jail. Therefore, you'll be given credit for time served. The court cost in this case is $67. However, you will not have to pay the $67 because the time that you spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. Mr. Moore, do you understand the state's offer?
Yes, Your Honor.
Do you think that the state's offer in your case is fair and just?
Yes, Your Honor.
And do you accept the state's offer?
Yes, Your Honor.
Mr. Moore, I'll follow the plea bargaining agreement that you have entered into with the state. Mr. Moore, please stand on the X next to your attorney, follow the directions of our clerk. Once you finish following her directions, you'll be free to go, and you have a blessed day. And Mr. Gall.
And Mr. Avila's on Zoom.
Blue light in front of you. You want to move this back down? So you're.
Next case is cause number 330446. Case is style of state of Texas versus Christopher Paul Aviles. Mr. Aviles, you can take your mic off of mute. Mr. Christopher Aviles, you can take your mic off of mute.
Yes, Your Honor.
Okay, Mr. Aviles, how you doing?
I'm doing okay. Let me turn my video on.
Okay. Okay, Mr. Aviles, you're here represented by your attorney, Mr. Dustin Galmore. Mr. Galmore, you have an announcement you'd like to make in Mr. Aviles' case?
Yes, Your Honor, we would like one additional announcement date. We have received the discovery and the video. We would just like a little bit more time to go over that and try to reach a resolution with the state.
January 21st.
Okay, the case is gonna be reset to January 21st. Mr. Aviles, your attorney, Mr. Galmore, will be given a copy of your reset date. Please stay in contact with your attorney. You are free to go. And Mr. Aviles, thank you for being patient with us this morning. You're free to go and you have a blessed day.
Thank
And
you, Your
Mr.
Honor.
You're welcome, Mr. Galmore. I think that's your last case?
Yes, thank you.
Okay, you're free to go as well and you have a blessed day.
Good. We have two ready on the motion docket that I think would be taken care of pretty quick.
Okay,
Garrett Chapman, it's number one on ours.
Chapman?
Yes, Your Honor.
Okay.
So 298980.
He was set for last week.
Yes, Your Honor.
Does anybody go get it? Oh, okay. We're in session in cause number 298980. Case of style of state of Texas versus Garrett Dave Chapman. We have Mr. Chapman present in court. Mr. Chapman, how are you doing?
Good, how you doing?
I'm doing fine. Mr. Chapman, you're here with your attorney, Mr. Joe Vasquez. Mr. Vasquez, how are you doing?
Good, Your Honor, how about yourself?
I'm doing fine. Mr. Gilliam, what is the recommendation probation officer? Or can you give us an update?
Yes, sir. Mr. Chapman paid off his balance in full. He still has some community service, but I'm aware of a plea deal between.
He was supposed to get a gift card? Is that?
Yes, Your
Okay.
Honor. He does have 3 days jail credit. I know they just had a new baby. The state would be okay if the court would give him credit for those 3 days in lieu of the gift card. I know he paid off everything else.
How much is the,
80 hours,
so,
but he paid $531 this morning.
so how much is owed? That's,
The
The community service.
Balance, he's paid everything.
I know, but what's the community service?
80 hours,
What was the gift card?
$240.
$240.
He had a $240 gift card that he was gonna get, but he already has three days would be $300 worth of credit, right?
Yes, Your Honor.
Okay, so, okay, you have a motion to, where we can give him that credit. I think, that normally, in the past, they've had a motion that they would, sign, and then I would put it on that motion. Now, Mr. Garrett, court is, part of the plea agreement. You paid your balance. And the court is going to, give you 3 days credit. That will go toward the gift card. I think the gift card was $280, you said?
I believe it was $240, Your Honor.
$240?
It was 80 hours, so it would be $240.
Okay, so that's $240. So, your 3 days credit, which is $300, will pay off the 240,
Yes, sir.
is what I'm saying. Now, Mr. Garrett, this has been a long road.
You don't even understand how
I understand.
I feel like it's been following me since
I understand.
2013. I couldn't. It got me out of jobs and everything.
I understand. I think, like I said, it's been a long haul. You know, we've had COVID. And then I think, if I'm not mistaken, one time you was on television, somebody robbed you or something. It was saying it was a robbery or something, or maybe you may have been a witness or something. That was about 2 years ago.
Oh, for real?
Yeah.
You know, telling man, I
Yeah.
had a long road,
Right.
different changes. This the
Yeah.
only time I got in trouble though, is 2013 wave. But they've been following me, like I said.
Okay.
It's just
Well,
been-
but you know, you can always put this behind you. Okay.
Sir.
And you just need to put this behind you and just continue to move forward.
Yes, sir.
Okay.
Yes, sir.
So nobody can hold you back but yourself.
Yes, sir.
All right. So it took you a while, but you paid your debt to society. Okay, which is commendable. And so we'll put this one to bed. Yeah, this one, yeah, I know it's been a long time because even before COVID, you was coming here.
Mhm. Like I said, it's been long, like real long for me. 'Cause
I understand. I'm looking at the year.
I was a kid. I was a kid when it happened.
Yeah, it says, well, this 2013, according to the offense date. Yeah, so that's 8 years ago.
Yes, sir.
Yeah. Yeah. So,
It was. Can I say one thing?
well, talk to your attorney first.
No, it was just about the offense.
But you can talk to your attorney.
Okay.
Yeah. Because you have a right against self-incrimination. Anything that you say can and will be used against you in the court of law.
Thank you very much. Nah.
Everything's good. Thank you very much.
Okay. Okay, so now, Mr. Chapman, court is going to be signing this order amending. Now, you're going to be doing a dismissal of, that's all he had left, right?
Yes, sir.
So y'all dismissing the motion to revoke probation?
Yes, Your Honor.
Okay,
Thank you.
okay. As you see, this is November the 19th. Okay, Mr. Chapman, they're going to do a dismissal. You're going to do it on the tablet?
Yes, Your Honor.
Yeah, okay. Oh. Here you go. Okay, so the state is going to be doing a dismissal of this probation. So you successfully completed probation. It took a while, but you but you got there.
Yes, sir.
Okay. So that's a good thing. All right, that's a good thing that you got it done. I know it took a while. I know last week you was in the hospital. You said that was
Just
you.
had a son.
You said, oh, congratulations.
Yes, sir. Appreciate it.
Yeah, congratulations. And we'd like to encourage you to, since you put this behind you, be the man that you know you can be,
Yes, sir.
and be the father that your son wants you to be.
Yes, sir.
All right.
Appreciate it.
Okay, no problem. So I'm gonna sign the dismissal. Once I sign the dismissal, you'll be free to go. Anything, Mr. Vasquez, is this your last case?
No, yes, sir. Thank you.
Okay.
I just sent it, Your Honor.
Oh, you did? Okay. 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 I think you're gonna have to do an MTRP dismissal. Yeah, you gotta, yeah, you have to do an MTRP dismissal. This is yeah.
there's a button on
I'm gonna send this back. Would you be able to go back into it?
It's not, I don't know if it's showing.
Because I didn't sign it. I just hit the omit. I don't know how to get it back from, is there a way for you to get it back? I don't know how you can get it. Release lock records. Yeah. We in session and cause number 321160. The case is style of state of Texas versus Pernell Lee Felder.
Yes, sir.
How you doing, Mr. Felder? I'm doing fine. Mr. Felder, you're here represented by your attorney, Attorney Jack Lawrence. Attorney Lawrence, how you doing?
Just fine, Your Honor. I think we've got an agreement on this too.
Y'all have an agreement?
Yes, Your Honor. Gillian, I believe it's basically the same situation. Mr. Felder's paid off everything. He owes, he only has 8 hours community service, which would be a $15 gift card, and he's got 4 days jail credit.
Oh,
which we would agree.
okay, that's fine.
He just paid this off.
Okay, so, Mr. Felder he paid his balance. And the court, is being asked to give him 4 days credit, right?
Yes, Your Honor.
And that 4 days credit will pay off the balance. Now,
18 hours, I believe.
you said it was 18,
Was 6 hours.
6 hours?
And it was $18, Your Honor, was the gift
Oh, I'm
That was
sorry.
it?
I'm sorry.
Okay, 6 hours. So that 4 days credit is gonna go toward the community service house. 6 hours, okay, so the 4 days credit is $400 of credit, which will go toward the community service. And you said that was $18?
Yes, Your Honor.
It was 6 hours.
6
It was
hours.
6 hours, but equivalent on a
$18.
$18 gift card or $18, okay. All right, so that's what we're gonna do. And could you,
I got it right this time.
yeah, okay. And so he's gonna draft up, you're gonna give me that modification?
No, sir.
Okay. Well, congratulations, Mr. Felder. I don't think you've been here a couple of times. Yeah, you look a little different with your head all covered up. Okay, can't hardly see you.
He still had to hitch a ride down here today.
Well, he got here, and that was the good thing. And he got this case behind him. That's also a good thing.
Do I need to sign?
No, that's what you said.
Sure.
see what these.
Okay. Mr. Felder, I'm signing the, this motion to modify. And also I'm signing the dismissal. Oh, okay. Signing the dismissal. Here you go. I just signed it. The motion
I
modified.
moved to dismiss too, so.
Yes, the case is being dismissed. I didn't even. Your MTRP is being dismissed.
It's Lawrence.
Thank you.
Todd LeBlanc was on there. Oh, there he is. We're gonna call, next case is cause number, yeah, his case is dismissed. So, Mr. Lawrence, you're free to go and you have a blessed day. And Mr. Felder, you're free to go as well and you have a blessed day.
Thank you.
All right.
Wait on me a second, I'll get you a copy. Okay. Thank you, Doc.
You can get this one here.
Okay.
Next case is cause number 315884. Case of South State of Texas versus Lamika Lachey West. We have Ms. West appearing via Zoom. Ms. West, how are you doing?
I'm fine. How are you?
I'm doing fine. Thanks for asking. Now, Ms. West, you're here represented by your attorney, who is also appearing via Zoom, Mr. Todd LeBlanc. Mr. LeBlanc, how are you doing?
Good, Judge. Thanks for asking.
Mr. Gilliam,
Yes, sir.
what's status on Ms. West's case?
She's been keeping in touch with the probation office. She did lose her job because some babysitter issues. All of her clients are paid for. She's paid all of her costs. The only thing she has remaining is 40 hours of community service.
Okay, but who's handling it? Okay.
I'll handle it. We would just request, I think, a recess, give her time to take care of the community service, Judge.
Okay, let me ask you, has she ever been given any credit toward, the jail time credit toward her?
She has 9 days, Judge.
Okay. Now, the 9 days, that would eat up her. Okay. Okay. Hey, you want to give her 9 days credit toward her, what is that, what is, she has?
It's 40 hours of
Community service, toward a community service?
Uh,
That would eat it up, because that's, yeah.
Yeah, yes, Judge.
Okay, so, let's get, he's drafting up a yeah. Now, Mr. LeBlanc, your client had paid her balance, and she only owed, she was required to do 40 hours of community service, but they're gonna give a 9 days credit. And so with the 9 days credit, the 9 days credit will take care of the 40 hours of community service.
And Judge, that's the suggestion I wanted to make because I think that's fair. She's having a hard time getting this community service done with small kids.
Okay. Okay, so we're drafting up a modification and then the MTRP is going to be dismissed. And Ms. West, you've been here. Actually, you appeared on several occasions. And so we like to commend you for taking care of your responsibilities on probation. We understand that you recently lost your job, but we'll be praying that you're able to get another job, and so you'll be able to take care of your children.
Yes, sir. Thank you.
Okay. And I'll be signing that dismissal. Mr. LeBlanc, I'm signing it. I just signed the modification. I'll be signing the dismissal, and this will complete Ms. West cases, her case. And Ms. West, again, thanks for being patient with us. You're free to go, and you have a blessed day.
Thank you. You too.
And you have a blessed day as well, Mr. LeBlanc. You're free to go.
Thank you, Judge. Have a good weekend.
All right, same to you.
Dismissal for Mr.
Okay, okay. This was, this was just getting ready to go.
Well, I have it on, I printed.
Oh, no, okay, no, I was, I'm talking about the other dismissal on the other case. So that's Mr. West, I mean, Mr. Chapman's.
Yes, sir.
Okay, Mr. Chapman, I just signed a dismissal. We can, could we give him a copy of that? And give him and his attorney a copy of that. Once you get your dismissal, Mr. Chapman, you'll be free to go. You have a blessed day. And Mr. Vasquez, once you get your dismissal, you'll be free to go as well. And you have a blessed day.
You too, Your Honor. Thank you very much.
Yeah, who we have? What cases you were here on? Is he hit it? Did he show? Oh. Did he show, call his name outside and see if he. Is that him?
Good morning, Your Honor.
Okay, we saw Kenneth Williams. Hold on a minute. Let's, man. Huh? No, are you Patrick Thomas?
No, sir, I'm Kenneth Williams.
Oh, okay. Okay. Okay, hold on a minute. I'm gonna have to, y'all just have a seat. I'm gonna have to get to him later. Just have a seat on one of the chairs that have the black and yellow tag on it. Okay, next. Let's see, Mr. Williams. Okay, Mr. Williams, this is Kenneth Williams appearing via Zoom. 329406 is the case number. Now, Mr. Williams, you're representing yourself?
Yes, sir, I am. Good morning, Your Honor.
Okay. Could we look at his case to see on his judge's explanation? Just hold on a minute.
Okay.
Huh? Yeah. Okay. Now, have you had a discovery yet in your case? That is, have you made arrangements with the district attorney to get discovery of the evidence?
Your Honor, I was just asking the court, if it pleases the court, I was gonna ask for more time to get that discovery and go over my case as well with Ms. Maxey. And I'm having a hard time getting in touch with my witness.
Okay.
So,
Okay, hold on a minute. Give us a reset date. Okay, now your case is gonna be reset to January 21st of 2022. Mr. Williams, please stay in contact with your, please stay in contact, actually, with your bondsman. You can, I guess, set up between now and then, you can set up a time to have discovery of the evidence as well as to negotiate with Ms. Maxey. Okay, so your case is reset to January 21st of 2022. Thanks for being patient with us. You're free to go and you have a blessed day.
you have a better day.
All right, thank you.
Thank you, Your Honor.
Okay. We have Abdullah Alabi. We're in session in cause number 328758, case of style of state of Texas versus Abdullah Alabi. Mr. Alabi, how are you doing? I'm doing fine. Thanks for asking, Mr. Alabi. For you to, your case was reset to give you opportunity to hire an attorney?
Yes, sir.
Have you hired your attorney?
No, sir, I wasn't able to.
Okay, so are you gonna still try to hire an attorney, or do you want to see if you qualify for court-appointed attorney, or do you want to wait to write to an attorney and try to represent yourself?
I don't mind a court attorney.
You would have to fill out a financial questionnaire. Okay, could you give him that questionnaire and that judge's explanation for him to fill out? You're gonna have a seat, once he give it to you, you're gonna have a seat in one of the chairs that have the yellow and black tape on it. All right. All right, just have a seat on one of the chairs that have the black and yellow tape. Alan Eaglin. Adrian Brown is pro se as well. How you doing there, Mr. Eaglin?
Doing okay. How about yourself?
I'm doing fine. Mr. Eaglin, have you hired your attorney?
No, sir. That's what I come to talk to you about today.
Okay.
I work in Baytown, Walmart Distribution Center, and the vehicle that I had, the motor went out in it, and I had to replace it. And
So you need
so
more,
got that money I put down on the vehicle, had to get.
so you need more time to get your lawyers?
Yes,
That's
sir.
what you asked?
Yes,
Okay.
sir.
How much time do you need?
At least a couple of months probably. 'Cause,
Well, we're gonna give you 60 days.
Okay.
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 Let's reset him 60 days. You can, yeah, you can stand on the X and get your, in front of the coordinator, get your reset. Once you get your reset, you'll be free to go and you have a blessed day.
Okay, I have one more thing, Your Honor. The vehicle that I had, I came here in September and I had to get that interlock device. So I need to get it out the other vehicle and get it in the one that I have now. And I came up here early in the week, excuse me. I called the place Smart Start on Benberg, I believe, and they told me I had to get a release from you to get it out the other vehicle to get it. Yeah, otherwise I would have already had, had it taken out the other, put in the one I have now, but that's what they told me. I had talked to Ms. Smith early in the week.
So now your other car is broke, you said?
Yes, sir.
Okay, it's
No
not
good.
total or anything, okay.
Yes, sir. So I gotta get it towed to the interlock device place, and they'll take it out, but they told me I need some.
They're
type of
just
release from
gonna
you.
take it out and put it in another car, huh?
Yes, sir. But like I said, I'll try to get it done before today, but they told me I had to get some type of release. or
Yeah, but
documentation from you.
I never heard of
They
that.
said your name. Yes, sir.
Yeah, but, well, the only problem is you're saying we signed an order to remove the interlock,
Right.
but then you're gonna have to sign another order to replace it. In essence, there's gonna be a gap between the time that,
Right, I understand. That's right.
yeah,
I didn't understand.
Put it all in one motion, Judge, and say.
yeah, we would have
one
to,
order.
we would have to draft something up. Normally, you would have to, now, do you have any proof that you can get to the court that you're saying that your vehicle is inoperative, that you purchased another
I
vehicle?
have a receipt on the vehicle that I purchased. I brought that.
Yeah.
Yeah. It's it's the only thing I could think of, because the other vehicle that's broken, it's I'm still paying notes on it, but I can't afford a new motor and pay notes, so I'm trying to get that device out so I can call them people to come get it before they, repo it while the device is in it. I'm kind of in a pickle, Damn.
Yeah, I think you still probably, if I'm going to leave it off for one vehicle, is any vehicle that you own or operate.
Yes, sir.
So, I mean, I don't see why they, because I think the order gonna have to be specific, removing it off a specific vehicle, because if we just do a regular motion to remove the interlock, then he can say, wait, I don't have to have an interlock on any vehicle, then we're gonna have to have an order to put it on. I don't know, we may have to,
Your Honor, I've texted my office trying to get the number to Smart Start. I'll call them.
okay, okay, yeah, he'll try to look into it. Do you need him to leave? Or,
No, I'm just waiting for the reply with the number.
okay, just have a seat, we'll get back.
Yes, okay.
Oh, wait, she needs you to sign your reset first.
Yes, sir.
Okay, that's Mr. Eaglin, right? Who is? Yeah, oh yeah, that's his paperwork, okay.
January 21st, and just have a seat so they can get that information.
We have Ashley Greer. Adrian Brown. And then I think we have Ashley Greer as well. Adrian Brown. I see that. Did we call him? He was in 279, wasn't he? Okay. This is cause number 330-416, case of style of state of Texas versus Adrian Brown. Full name Adrian Brown. How you doing, Mr. Brown? Okay, Mr. Brown. I see you have a felony case set on December 13th of 2021. Is that correct? Now, do you have an attorney represent you in this case? Okay, you say you asked for a court-appointed attorney for both your misdemeanor. Did you ask for, where was that done? You said,
At the jail.
okay. So, could you look up his, okay. Mr. Okay, what we're gonna do, you're gonna have to fill out some paperwork. First document is called Judge's Explanation of Rights to Defendants Without an Attorney. And then you will have to fill out a financial questionnaire. Okay, now, Mr. Could you give him a judge's explanation of rights to defendant without an attorney? Now, Mr., let me do this. I'll just go over the judge's explanation of defendants without an attorney. That first document, do you see that title, Judge's Explanation of Rights to Defendants Without an Attorney? Okay, and it reads, as a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Do you understand that option? Number two, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Do you understand that option? And number three, you may represent yourself. Do you understand that option? Now, if you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. At the bottom is this document. It reads, defendant's choice, mark initials next to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you put your initials on the first line to the left. If you have hired an attorney, then you will put your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for court-appointed counsel, then you will put your initials on the third line to the left. If you have a court-appointed attorney, then you put his name on the fourth line to the right and your initials on the fourth line to the left. If you want to waive your right to an attorney and represent yourself, then you put your initials on the fifth line to the left. Do you understand? Now, once you finish initialing one of the 5 lines, then you will sign at the bottom of this document where it says defendant, and you will date it today's date, November 19th of 2021. Okay, you can go ahead on and make your choice on that document. Oh, here the pencil. Oh, okay, hold on a minute. Yeah, he can have a seat if he's gonna choose to hire an attorney
He wants to apply for a court.
or apply for a court appointed attorney, then you fill out that financial questionnaire.